Good morning, everyone. Welcome to part 14 of this lecture series on the rules on criminal procedure. This morning, we are going to discuss about judgment. Okay, so let me share my screen with you. Rule 120, judgment. Okay, now what is judgment? When you say judgment, this is the adjudication by the court that the accused is guilty or not guilty of the offense charged, and that the court will likewise impose the proper penalty and civil liability, if any. Judgment is a judicial act, meaning it is an act from the court which settles the issue, fixes the rights and liabilities of the parties, and is regarded as the sentence of the law pronounced by the court on the action or question before it. Now, what is the difference between a judgment and a ratio decidendi? Usually, class, you will be able to read some court decisions, and not all of it will form part of judgment. Some of it will be a mere ratio decidendi. A judgment pronounces the disposition of the case. It pertains to the facts in issue, while a ratio decidendi provides a basic reason for such determination. A ratio decidendi class does not resolve the fact in issue. It merely provides for some opinion made by the court. It does not directly resolve the case. What directly resolves the case is the judgment. A ratio decidendi can be an argument in support of the judgment, which is not directly related to the fact in issue. So what is a final order? When you say final order, it finally disposes the whole subject matter, or it terminates a particular issue. No, it does not leave anything to be done, but to enforce by execution of what has been determined. So when you say final order, this is subject for implementation or execution. On the other hand, an interlocutory order is an order by the court which does not finally terminate the proceedings, no, but is an order by the court in the course of the trial prior to its termination. So what are the requisites of a judgment? A judgment must be written in the official language. It must be personally and directly prepared by the judge. It must be signed by the judge. And lastly, it must contain clearly and distinctly a statement of the facts and the law upon which it is based. So the judgment must contain the following. If the accused is convicted, then the legal qualification of the offense constituted by the acts committed by the accused and the aggravating or mitigating circumstances pending or attending its commission. The participation of the accused, whether as principal, accomplice, or accessory. The penalty imposed upon the accused and the civil liability or damages caused by the wrongful act or omission, unless a separate civil action has been reserved or waived. If the accused is acquitted, then the judgment must contain whether the evidence of the prosecution absolutely failed to prove the guilt of the accused or merely failed to prove his guilt beyond reasonable doubt. Okay? So, and in either case, the judgment shall determine if the act or omission from which the civil liability might arise did not exist. So there are two types of acquittal as a matter of fact class. An acquittal can be based on reasonable doubt, in which case, if the acquittal is based on reasonable doubt, then there can still be civil liability arising from the crime. The type of acquittal which will not allow a grant of civil liability or damages arising from the crime is when the court pronounces that the prosecution absolutely failed to prove the guilt of the accused, or that the act or omission from which the civil liability might arise did not exist. Okay. Now, what if there are two or more offenses charged in the information and that the accused got convicted? Now, as a rule class, if there is an information, there should be one crime. Now, one crime for every information. But it happens, class, sometimes that due to some lapse, there are several uh, several crimes or offenses that were contained in a single information. So what happens in case that two or more offenses were contained in an information? No? So if the accused is convicted in a proceeding where the information contains two or more offenses, then the court may convict him of as many offenses as are charged and proved and impose on him the penalty on each offense. Now, what if the offense charge is different from that which is proved? So, for example, the crime charge is theft, but during the course of the trial, the testimony had established has established the crime of robbery. So there is a variance, or there is a difference between the offense charge and the offense proved. So as a general rule, an accused can be convicted of an offense only when it is both charged and proved. So if it is not charged although proved, or if it is not proved although charged, the accused cannot be convicted thereof. There is an exception. One, no, when there is a variance between the offense charged in the complaint or information and that proved, and the offense as charged is included in or is necessarily included in the offense proved, then the accused shall be convicted of the offense proved, which is included in the offense charge, or of the offense charge, which is included in the offense proved. So what do we mean by this? For example, class, the crime of murder and homicide. If the crime charge is homicide, but upon presentation of evidence, the crime proven by the testimony and the documentary and object evidence is that of homicide instead of murder. The crime charge is murder and the crime proven is homicide. Because, for example, there is an absence of a qualifying circumstance. There is no treachery, there is no use of licensed firearm, etc., etc. So, can the accused charge of murder be convicted of the crime of homicide as that proven during trial? Answer, yes, because homicide is necessarily included in the crime of murder. So if there is a variance between the offense charge and the offense proved, then the accused can still be convicted of the offense proved if the offense proved is necessarily included in the offense charge. Now, what is the effect of a judgment of conviction upon a minor? What if the accused is a minor? As a matter of fact, technically speaking, a minor accused is what? More properly called as a child in conflict with the law, or child in conflict with law, CICL. Now, you do not call them accused. So what if a child in conflict with law is convicted of a crime? As a general rule, the courts shall promulgate the sentence and ascertain any civil liability which the accused may have incurred. The sentence, however, shall be suspended without the need of application pursuant to PD 603. So the sentence will not be imposed. There will be a suspension of sentence without need of application, meaning the accused does not need, or the child in conflict with law does not need to apply for suspension of sentence automatically. If he is convicted, the sentence is suspended and he will be committed not in the jail or the BJMP detention facilities, but the child in conflict with law will be committed under the care of the DSWD until he reaches the age of 21 or until the court so determines. There is an exception to the suspension of sentence of a child in conflict with law who was convicted by the court. Number one, he has enjoyed a previous suspension of sentence. Number two, if he is convicted of a crime punishable by death or life imprisonment. Third, the child in conflict with law is convicted by a military tribunal, or if he is already of age at the time of the pronouncement of the sentence, even if he was a minor at the time of the commission of the crime. Now, what is the rule? If the minor had already reached the age of majority upon promulgation of his sentence, he is no longer entitled to a suspension of sentence, and the time spent during the period of his confinement shall be credited to his actual service of the sentence. No? Furthermore, he shall still be entitled to the privilege mitigating circumstance of minority, and therefore the penalty will be reduced to 1 degree lower. Okay. Now, what do we mean when we say promulgation of judgment? When we say promulgation of judgment, this is the reading of the official proclamation or pronouncement of the judgment of the court. Now, this is done by reading in the presence of the accused and any judge of the court which it was rendered, or when the judgment is one of conviction for a light offense in the presence of the accused counsel or a representative. So who has the authority to promulgate the judgment? As a general rule, the judge who rendered the judgment will have the authority to promulgate the judgment. There are certain exceptions. One, when the judge is absent or is outside the province or city, then the judgment may be promulgated by the clerk of court. And if the accused is confined or detained in another city, the judgment may be promulgated by the executive judge of the RTC having jurisdiction over the place of confinement or detention. Now, when the accused is absent in the promulgation of judgment, still the promulgation can be made by recording such judgment in the criminal docket and serving him a copy thereof in his last known address or through his counsel. If judgment is one of conviction, the accused is absent without justifiable cause, the court shall order his arrest and he shall lose the remedies available in the rules against judgment, and his bail shall be forfeited. So these are the consequences of the absence or unjustifiable absence of the accused during promulgation. He will be ordered arrested. He shall lose the remedies available under the rules and his bail forfeited. So there are instances where the judgment may be promulgated even the accused is not present. In case of judgment of acquittal, in case judgment is for a light offense, in which case the promulgation is to be done in the presence of the counsel only for the accused or a representative. And then accused fails to attend the promulgation despite due notice, or if he jumped bail or escaped from prison. Notice must be given to the bondsman, warden, accused bailor, and counsel. So a judgment of conviction may, upon motion of the accused, be modified or set aside before it becomes final or before appeal is perfected. Now, what are the remedies of the accused when the judgment fails to, what is the remedy of the private offended party when the judgment of the court fails to award civil liability? He can file appeal, he can file certiorari or mandamus. What is a mitimus? A mitimus is a process issued by the court after conviction to carry out the final judgment, such as commanding a prison warden to hold the accused in accordance with the terms of the judgment. So a mitimus class is akin to an order of the court to detain the accused or continue his detention if he was previously committed to prison. Acquittal. An acquittal is a finding of not guilty based on the merits. That the accused is acquitted because the evidence does not show his guilt beyond reasonable doubt. An acquittal can also mean a dismissal of the case after the prosecution has rested its case upon motion of the accused on the ground that the evidence fails to show beyond reasonable doubt that the accused is guilty. What is a reasonable doubt? A reasonable doubt is the state of the case which, after full consideration of all evidence, leaves the mind of the judge in such a condition that he cannot say that he feels an abiding conviction to a moral certainty of the truth of the charge. So when you say reasonable doubt, the judge's mind is uncertain whether the accused is guilty or not. So in case of a doubt, then the accused will be acquitted. So when does judgment becomes final? No? A judgment becomes final after the lapse of time for perfecting an appeal, because if the accused got convicted, then he can file an appeal. So during the time that he can file an appeal, and if the accused failed to file an appeal, then the judgment will become final. No? When the sentence has been partially or totally satisfied, okay, when the accused has expressly waived in writing his right to appeal, or when the accused has applied for probation. So class kasi, if the accused applied for probation, then he will be necessarily accepting the judgment of the court. And therefore, upon application for probation, the judgment becomes final. Okay. Now, what are the instances when the trial court loses jurisdiction even before the lapse of the 15-day period to appeal? The defendant voluntarily submits to the execution of the judgment when the defendant perfects an appeal, when the defendant withdraws his appeal, when the accused expressly waives in writing his right to appeal, and when the accused files for probation. So what do we mean by entry of judgment? This is the recording of the judgment or order in the book of entries of judgment which constitutes its entry. It is the record, no? The record contains the dispositive part of the judgment order and shall be signed by the clerk with a certificate that such judgment or order has become final. Okay? So if a child in conflict with law has been convicted, he is entitled to an automatic suspension of sentence without need of application, except when he has previously enjoyed a suspension of sentence. He is convicted of a crime punishable by death or life imprisonment if he is convicted by the military tribunal, and fourth, if the offender is already of age at the time of sentence, even if he was a minor at the time of the commission of the crime. So this is only by way of emphasis because this was contained in the previous slide. No? Okay. So probation. No? If the accused is convicted, he can apply for probation. Meaning if he applies for probation, then he will be released. Now, instead of serving his sentence inside detention facilities, he can be released from prison. So, but there are certain offenders who are not qualified from probation. One, those sentenced to serve a maximum term of imprisonment of more than 6 years. So, if the maximum term of imprisonment is more than 6 years, then the accused is disqualified from availing of probation. Those charged with subversion or any crime against national security or public order, those previously convicted by final judgment of an offense punished by imprisonment not less than 1 month and 1 day, or a fine of not less than 200,000 pesos. Meaning to say, there was already a previous judgment of conviction And the imprisonment imposed is not less than 1 month and 1 day. Those who have been once on pardon, those who are already serving sentence at the time of the probation law became applicable. So this ends our presentation. I'll see you again next meeting. Thank you.